attorney.
No, ma'am.
Okay, well, I don't.
Don't listen. Don't shake your head at me. Oh. Versus Chloe Whitsett.
Edward Drukas on behalf of Chloe Whitsett, who is approaching, Your Honor.
I'm sorry, Your Honor. I'm dismissing my court-appointed attorney and representing myself.
Okay, start with this. What's your name?
Chloe Whitsett.
Okay. And you're intending upon this matter?
At this time, yes, Your Honor, I am. I am dismissing the court-appointed attorney at this time, yes.
Okay, what's going on?
Until my family and I decide what law firm we are going to choose, I will be representing myself.
Okay, all right. So you need time to seek a attorney?
Well, not really, but I have a request at this time as I am representing myself.
Well, not until such time as I relieve Mr. Drukas.
Okay, thank you.
That's what I'm trying. I have not done so.
Okay.
So I'm trying to figure out what the issue is ending upon doing.
Dismissing the court-appointed attorney and representing myself.
Okay.
I'm sorry. At this time, I can't make it any clearer, and I don't understand.
You're not making it very clear to me at all.
Okay.
You're not listening.
I'm confused.
Just talking. Are you going to hire an attorney?
Yes.
Or are you going to represent yourself?
Today, Your Honor, I'm going to represent myself. If my request is denied by you, then I will be hiring an attorney. I can't make it any clearer than that.
So if I relieve Mr. Drukas, you're going to represent yourself?
Yes, sir.
So if they set it for a preliminary examination, you're ready to go?
This is I'm representing myself today. I don't know what all happens today, but I'm talking to the judge without the court-appointed attorney.
No, ma'am.
Okay, well, I don't.
Don't listen. You don't you dare just lean on my podium and pretend like that. Not here. Okay, here's what I'm gonna do. I'm gonna pass the matter because if you come back up and start banging your nails on that podium, you're gonna be going with Mr. Allen. You may have a seat. Don't shake your head at me. Oh. Mr. Allen, might want to have a conversation with her and tell her that she better check herself before she comes back up here. Who wants to go next? Christian Philippe calls the case, People versus Whitsett.
Apologies on behalf of people.
And Edward Drukas on behalf of Chloe Whitsett.
Your name?
Lucinda.
Apologies on behalf of my client for earlier. I did have an opportunity to speak with her during that break and go over the process of where we are, what's going on right now. She did tell me that she would like to obtain a new attorney. So in the meantime, I can assist her with getting a copy of the discovery, getting a copy of the videos, which I don't have yet. I was going to be asking for an adjournment today to obtain those. So ultimately, I'd be asking for at least a 2-week adjournment. And I talked to her about her behavior in court, and I think that she has an understanding of that and will abide by anything the court orders her to do. So with that, I'd be asking for an adjournment of today's hearing.
Is all of that correct, Ms. Whitsett?
Your Honor, I would like to apologize. I had complete zero understanding, but yes, that is correct.
Ms. Whitsett, let me tell you something. Locked you up. You're lucky that I just took a deep breath and said, I don't know what's going on. I'm just asking her questions. And you come in here, I don't think we've ever seen each other. And you just come in here disrespecting me in this court. And I'm going to tell you something else. That man standing beside you right now, It's the only thing that saved you from going to jail. I had pretty much made up my mind that when I came back out here because of what you had done, you were gone. So while you may not want him representing you, he just saved you. But remember one other thing. Funny thing about judges, we have exceedingly long memories. You come in here acting like that on the next day, I'm not even going to ask any questions. You are just going to go. Are we clear?
Yes, Your Honor.
April 11th, 2024, 9 a.m. as your invite indicates. It's time the defendant's bond will continue.
Thank you.
Court does call the case of the People versus Latrice Lee.
Ashley Lonnie for the people.
Michael Gaddy, Assistant Public Defender on behalf of Miss Lee, Your Honor. She is approaching.
And your name?
Hey, Latrice.
Thank you.
Your Honor, I have had a chance to speak with Ms. Lundy. I've had a chance to speak with Ms. Lee. The people have tendered an offer that would resolve this case on a misdemeanor basis. At this point, I think Ms. Lee is going to avail herself of that offer, but we'd ask the court to adjourn it very briefly so we can get all her rights and everything, and also kind of check her driving record and make sure her driving, kind of explain to her what the license penalties are going to be.
Understood. May 1st, 2025, 9 a.m. as your invite indicates. Bond will continue. You're welcome. Let's call the case. People versus Derek. Is it Panaritos?
You can reach make this for the people.
Brian Bowling on behalf of Mr. Panaritos, Your Honor.
Your name, sir?
Derek Panaritos. Judge, waiver form that's being submitted to you now.
All right. Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also, preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Your Honor, I'd waive formal reading of the charges, stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
June 25th at 1:30 p.m. with Judge Conley.
June 25th, 2025, 1:30, Judge Conley.
Thank you, Your Honor. Thanks, Judge.
Thank you. Bond continued. Court calls the case of the People versus Antoine Patterson.
And Assistant Public Defender on behalf of Mr. Antoine Patterson. He is here.
So I know somebody ran out. She was nice enough to tell me, just a minute, I'll get him. That's unlike you.
Yeah,
I know.
I gotta do better. Mr. Patterson, state your name for the record, please.
Thank you.
Judge, we are asking if the court can give us just 1 week. Offer made by the people. Mr. Patterson is very inclined to take that offer. There were just some terms that we needed to tweak a little bit.
I can give you 2 weeks. Is there a reason you don't want 2 weeks?
No reason at all.
Then why'd you ask for 1?
Just trying to, keep it small.
Never her strong suit. Probable cause, May 1st, 2025, 9 a.m. Bond continued. All right.
Thank you.
Thank you, sir.
Okay.
And thank you, ma'am, for letting me know that he was out there. Not letting me know anything. He just showed up without a client. Thank you. Court calls the cases of the People versus Carlos Payne.
And it's on behalf of the people, Your Honor.
Assistant Public Defender Chelsea Virgil is with and on behalf of Carlos Payne, who approaches.
Good afternoon. Okay. Carlos Payne.
Thank you, sir.
Your Honor, we are asking for an adjournment on Mr. Payne's cases. We'd like to have a plea discussion, and we are missing the video discovery on one of his cases.
So you got video that you're waiting for on one of them.
Correct, Your Honor.
Probable cause conference without objection, May 6th, 2025, 9 a.m. Bond continued. All right. Thank you, Mr. Payne.
All right. You have a good day.
Court calls case People versus Tyler Pittman.
The children appearing on behalf of the people.
And good afternoon, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Pittman, who's appearing to my right. Mr. Pittman, could you state your name for the court?
Tyler Pittman. Good afternoon.
Your Honor, I did fill out a green sheet. I am requesting to adjourn this case. Mr. Pittman does have another case that's pending in 14B. His court May 1st in that case. But the main reason we're seeking to adjourn is to put together a more compelling mitigation to continue discussions with the people.
Part of that, just so that I'm clear, part of that is regarding the other matter on May 1st.
Yes, Your Honor.
All right. May 6th be enough time after that one here.
I think that should be.
Probable
Thank
cause
you.
conference, May 6th, 2025, 9 a.m. Bound to continue. All right.
Thank you, Your Honor.
Case People versus Michael Roberts.
Brian Bowling on behalf of Mr. Robertson, who hopefully should be on Zoom, Your Honor.
Yes, if you could unmute and state your name, please, sir.
Michael Robertson.
Judge, we're asking this matter be set for an exam. To my knowledge, all the discovery is complete.
Would people have their witnesses available the 29th?
That's fine.
Preliminary examination in person will be set April 29th, 2025, 9 a.m. That is before me. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus. Tried to correct the name, but I don't know. Is it Javon Smith?
Andrew Childers appearing on behalf of the people. Like, yeah, it's just a public defender on behalf of. I don't know, to my right. State your name, Mr. Smith.
Good afternoon. Javon Smith.
Thank you.
Your Honor, this matter, may we approach?
This matter's been going on a while.
Yes.
Come on. Should reflect that been a bench conference. We're going to set this for exam. Realize that as we've been dealing with, and it's really no secret, but there are some issues with medical records. Rather than having to explain that issue to another judge, I'm going to set it before me. I'm going to set preliminary examination in this matter in person June 3rd, 2025, 9 a.m. Like I said, that's before me.
Thank you. Your Honor, if by chance we do get the records and we want to waive, we'll give notice to the people and so that they can.
Correct. If let's say you get them and it's before that date, you can contact my office. If we can get everybody in, we can get that accomplished for you.
Thank you, Judge.
All right. Thank you. Bond continue. Thank you, sir. Court calls the case of People versus David Sneed.
Mr. Sneed, who appears via Zoom.
There you are.
Mr. Sneed, can you state your name?
David Sneed.
Thank you.
Your Honor, we're just asking to set this matter for preliminary examination today.
For extended, Your Honor, which I will consider rejected, the offer was to plead to an added count 2 of stalking, and then plead for dismissal of aggravated stalking. I think we know what's happening to that. That was her request.
All right.
Mr. Sneed, are you aware of that?
I didn't hear what she said.
Are you aware that there was previously an offer made and are you rejecting it?
Oh, yes.
All right. So discovery is complete. People have their witnesses available the 29th.
I'm sorry, Your Honor. Thank you.
Preliminary examination in person will be set April 29th, 2025, 9 a.m. before Judge Barr.
Thank you.
Bond will continue.
The bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan, the property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you. All right.
Thank you.
I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something.
Yes, go ahead.
Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that, because I'm not.
The reason that I mention all of this, Your Honor,
Go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
Right. Thank you. Ma'am,
Yes, Your Honor?
what do you want to tell the court?
Well,
just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then you are not a named party. So if you're not consenting to this court's jurisdiction, sit down. You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and then you can go challenge it. With who?
With Whitlow. Ms. Whitlow.
Then you need to go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to.
I don't know what you need to do, but.
Well, let me respond.
To what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting.
You're recanting what?
What I just stated.
Which part?
The part that not. Oh, I lost my spot. Not consenting to this court's jurisdiction. So I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment. Oh,
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
okay.
You know what? Here's the problem. You've not filed why, on those grounds, why I'm hearing from you.
Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false.
answer and counterclaim to what?
To their complaint for eviction.
You have a lease with, allegedly, with Miss Whitlow.
Correct.
Then that is who.
And that's what makes real courtroom so fascinating. Every hearing is a reminder that success in court isn't just about what you know, it's about how you present yourself, how well you understand the process, and whether you can maintain credibility when the pressure is at its highest. From tense confrontations to critical legal decisions, today's proceedings showed just how quickly things can change inside a courtroom. What moment stood out to you the most? Let us know in the comments, and don't forget to subscribe for more real courtroom breakdowns and legal analysis.